Wait, please, Lord. Back to mention item number 16 to 20, my lord. Here I was appearing for the appellant and I returned the briefs. I am informed me that they are in the process of engaging new set of counsels. So this may be listed after
Set of counsel.
new set of counsels. It may be listed after 3 weeks, my lord, so that they can.
I am for the respondent.
Yes, yeah, for the respondent.
1 week. Because it is an old matter.
May be difficult in a week.
If they want to engage, suppose new set of counsel, in that case, most probably 1 week
Yes.
may not be sufficient. So let it be otherwise 2 weeks.
3
or
weeks.
3 weeks.
Yes.
No, because the difficulty is there is an esteemed interim order operating.
Oh, achha.
Actually, this
Yes.
melody.
My lord will make that clear that if they don't engage, my lord, it will be taken up for consideration.
With that interlocutory order.
But otherwise, you are being engaged, you are continuing in the case.
I was, my
Probably-
lord. There have been some difficulties. They are not providing me the necessary
Assistance.
That is the difficulty. Earlier also, London Senior Counsel D. Majumdar was appearing. On his request, I started appearing. I am not being furnished this particular.
Okay, this time let it be after 3 weeks.
My
3
lord,
weeks. Yes.
my lord will kindly make an observation. In the event of non-appearance
Yes.
of the counsel for the appellant, the interim order shall be vacated. That observation at least my lord can make.
What kind of stay is it? I mean,
Actually, the fact is like this, they order 39 order application, there was and stay order by the landed court below. Then that was put under challenge under section 115 of the CRPC. And that is not the correct provisions. It is under order 41, rule 1R. That is the correct provisions. So therefore, interlocutory application under that provision is not mentionable. So that is the only thing.
I will
My
take
lord
a
will-
call on the next day, man.
Huh?
My lord will take a call on the next day if they don't appear, madam.
That's my lord will make that
but
observation.
the question is that I have been engaged as a counsel. So just get the instruction or information because it is the duty otherwise.
Yes.
16, 17, 18.
20,
Don't cheat with it.
up to
Same order
20.
will be there. Same order will be there. Have Mr. D. Pani, the learned counsel for the petition, also have Mr. D. T. Tara, the learned petition, learned counsel for the respondent. It is submitted by Mr. D. Pani that the petitioner side is going to engage the new set of appellant, the new set of counsel, and hence he wants to withdraw the his deeds of the present petition. And accordingly, submitted to get the proper instruction. Some more time is required, and accordingly, let the matter be listed for hearing after 3 weeks. In that context, learned counsel Mr. T. Tara has submitted that the matters are all pending, and the stay is also operating in all these cases, and hence pray that on the next date of listing, and NDPS should be made to take up the hearing of this case. Accordingly, and let the matter be fixed after 3 weeks. It will be a date fixed.
After 2 weeks, can you make it after 2 weeks without a
I'm
specific?
giving you 3 weeks, because most probably, yes, you are saying he is asking for 2 weeks.
Let it be 3 weeks. They are stationed in Mumbai.
List after 3 weeks, 3 weeks, any date or list after 3
Hey,
weeks.
it's
List
after.
after 3 weeks. And if in case of non-appearance of the petitioner side, when this counsel, matter may be heard, matter may be heard, or stay order may be vacated.
And we don't, registry may be directed to delete the name of
Not,
Deepangin.
not now.
Not now.
Not now.
Not now.
Let us.
Let the instruction come.
That will not, that is the
Otherwise,
case.
in the meantime, if the other council has been engaged, definitely it will be informed to the registry, or if the presence is, if the other council is present before the court, then definitely will
Yes,
be the registry to India.
Then, my lord, I request, my lord, for after 2 weeks. After 2 weeks, without
But
specific.
this construction.
No,
was
without,
pending.
without specifying the date, let it be after 2 weeks. Then it will come after 3 weeks.
Why?
No, but there is some urgency because otherwise it's a very old matter. I request my brother to accommodate me also because I am also hard pressed. I have been cooperating whenever.
He stays in Mumbai.
The communication is there. Kindly after 2 weeks.
After 2 weeks. Status.
Oh, fine.
Not sure I beg to mention, I beg to mention item number 12, Lordship.
Item number
12,
1, 2.
yes, Lordship.
Yes.
That service of notice upon the respondent number 2, Lordship, has not been returned. That is the case service may be awaited and
You are for one.
Yes,
from PP.
for the state.
I mean-
Matter is in orders, my lord. Necessary order may be required to be passed if the service is not completed, my lord.
Yes, it is not completed. That
Has
is
to be
Completed.
rectified.
What is the report of? So,
not returned.
not yet returned.
Yes.
Let's just wait. Item number 12. Item number 12. Both dice. 16 ways, 21 ways. Yes, I think it's still awaited. I don't
Yes,
know when you have taken steps. On 4/7, so it can be awaited.
Yes,
Hard MSMD, the learned counsel for the petition, also hard Mr. J. Singh, the learned PV for the state of, for the state respondent. Number 1. From the office notes, they did. From the office note, they did, 21/7/2023. I think that there is the service, no, AD card, neither the AD card nor the service report for the respondent number 2 is received by the concerned section. Let the service be awaited for the next date.
Lordship,
Matter be-
a date may be fixed
Matter be listed.
on
Yes, say your, as per your convenience, we are going to fix.
28 August.
28/8.
August, after 1 month, because I have some other matters in other.
On 28 only.
That is why, Lordship.
No, on 28 you have. other
28,
28 or 20.
28 August.
Let the matter be listed on 28.
Okay.
May I please, Lordship? Lordship, I beg to mention item number 8, Lordship.
8.
8.
Yes, it is an order column. What happens?
Lordship, dusty service was in fact affected in the last occasion, Lordship. But still, I have not got any instruction from my client whether they have served a copy or not. So I prepared some more time, Lordship.
These are the orders column. Let the matter be reached first. Okay.
Lordship, I have a matter,
You have
other
an
court,
matter.
Lordship, that's why, Lordship. Otherwise, I could have waited.
Item number 8. The justice service was allowed.
Allowed.
Then
Uh,
you have not filed the affidavit till date.
No, I have not got any instruction from my client, whether he has served, I have called him, but then he's unable to provide me the instruction. It's an interior place, Lordship, so why they must be facing some difficulties, Lordship.
So Mr. J. Gini, you are Mr.
Lordship, JJ.
Had Mr. J. Gini, the learned counsel for the petition, and also had. State is not there, na?
State is not there, Lordship.
You are for evidence, respond number, which respondent, number three?
Three.
Three. No one has represented the respond number one and two. The name of two redundant counsel are being reflected in the cause list. Further, it is submitted by Mr. Tijini that the affidavit could not be filed regarding the justice service as he has not received any instruction from a client regarding the service of the notice through testimony. Accordingly, learned counsel for the petitioner is hereby asked to submit the affidavit on the testimony on the next fixed date on or before next date. Let the matter be accordingly listed. After 3 weeks.
3 weeks, 3 weeks. Lordship. Lordship, in interim, there is an interim.
Interim is
But maybe
Interim
continue.
order be continued. to next date.
Item number
Yeah,
9,
Your
Lordship.
Your Lordship, I'm appearing, I'd like to mention for the item number 11 from the respondent side. The advocate is Abhijit Bhattacharjee. He's from Assam, so he's seeking an adjournment and he's requesting the Honorable Court to fix the matter for the 9th of August.
You are on item number 11.
Yes, Your Lord.
10 and 11. 10 is along with 11. I think. Oh,
No, madam, 11 is
sorry,
separate.
I didn't know 11. Separate.
11 is an application filed by the estate, man, for cancellation of the bail. So
Why
on the
this
last, yes, ma'am, on the last occasion, we were directed to serve a notice.
Hmm.
And accordingly, we have done it. Since they are appearing, my lord, they must have received the notice, my lord. This may be recorded.
Mr. T. S. Seri, we ran a big for this written for the petitioner appellant. And also heard you are Mr.
Evilly.
Learned counsel appearing on behalf of the respondent side. Does it seem that the service is already completed from respondent? However, it is submitted by the learned and this counsel for the respondent that the senior and this counsel is from Assam.
Yes, Your
From
Lord.
Assam, and accordingly, they paid an adjournment today. Fair allowed. Let the matter be, you want to fix.
9th of August. 9th.
You want 9th of August?
Yes.
The matter be accordingly listed on 9th of August.
Oblige, Your Lord.
Lordship, I beg to mention item number 9 also. Item number 9, Lordship. Here in respect of respondent number 2, Lordship, service report is still awaited, Lordship. Last occasion, we have taken registered AD post to AD steps was taken, Lordship. Now, Lordship,
One PK Dewey council.
Lordship, I have taken instruction from.
No. Name of one PK Dewey is reflected in the cause date. Who is he?
Lordship,
He is appearing for whom?
he's for respondent, I'm for the petitioner.
No, you're for the petitioner. He is appearing for respondent number 1, 2, 3, who?
Lordship, all. Lordship.
You know what you submitted?
Lordship, last what happened is he was representing all the respondent, but then in between that, Lordship, during the pendency of this case, the husband died, Lordship. But then his wife was impleaded accordingly, Lordship. So service was to be taken, Lordship. Steps was to be taken.
The implement has already been there.
Lordship, it's already been Lordship. Notice was to be served, Lordship. Step was to taken from my side, Lord. Since he was to be implemented, Lordship, since we have filed one IA, it's yet to be disposed of. It's pending,
I is still pending.
Lordship, for implementation, Lordship.
Direct consider. Plan to important thing. Important thing. Pay good. Now your delay condonation is still pending.
Lordship.
Section 5 is still pending.
Oh, Lord, section 5 means, I think that is for condonation of delay, Lord.
Yes, condonation and delay is still pending. The appeal has not been get registered or what? What is the position of the appeal now? I mean, and the implement, the order of implement petition is of IAS.
Lordship, maybe I have not properly briefed with the case.
One
Lordship.
I disposed of. It is IAS 70.
Lordship.
You see all the matters. One I is 70, we have already been disposed of. Another I is 221, still pending. One is for limitation. Again, one is for. So there are 3, 4 I's are there.
Lordship, may kindly see the office note, Lordship, since this matter was appeared by one of my learned friend in the last occasion. Briefing is also with him, Lordship. He's out of station, Lordship. As per his instruction, Lordship, he has sought for dusty service, Lordship. But then I was not properly being instructed, since file was.
Service in which I? In I, like limitation, in I improvement, where?
Lordship, I think in all the IA as well as in the main case, maybe, Lordship.
That will be listed code. Not listed legally, but we according to the- The JJ, the current consequence, let the matter be listed after 2 weeks.
Lordship, I may be allowed to take dusty service, Lordship.
Where? It will come after 2 weeks, you just prepare the instruction and then.
Lordship. Much of it.
May I present? You also have to mention item number 14 and 15. Can this matter may be listed day after tomorrow? Day after tomorrow.
Why?
I also, yeah, one I has been filed by the respondent for the substitution of the respondent. However, we have filed our reply in this IA and it need to be heard, you know. So
We have
however.
filed a reply today only, and I've been informed that Mr. L. Bam, who is conducting the case, is out of station. So let it be taken up day after tomorrow.
Day after tomorrow.
Yes,
Madam. I'm appearing for the applicant in item number 14 and in item number 15, I'm appearing for the respondent.
In item number 15, you are appearing for?
On 15, I'm appearing for respondent 1 and 3, and since the respondent number 2 has passed away, my lord. So in item number 14, I'm seeking for the implement of the son of the respondent number 2. So let it be taken up in day after tomorrow.
Both 14 and 15 list.
You know,
Day after
there's a
tomorrow will be, day after tomorrow will be
16, 26,
26. Yeah.
26. And there's an entry on the, it may be continued.
Interim was there.
Yes, yes.
Interim be continued. We'll get an account.
Highly.
Yeah, and I beg to mention item number 2.
Yes.
This matter may be fixed on 4th of August, you know, because the council will be free on that particular day and we've taken consent from the respondent as well.
Council is where?
He's out of station today. So it may be taken on 4th of
You are
August
appealing for petitioners?
for the appellants, for the appellants.
Pardon us, so, for the appearance side. This the matter accordingly on 4th of August.
On 4th of August. I know.
Lordship, I beg to mention item number 13,
13.
service to the respondent number two is still awaited and LCR is also not yet received, so matter may be taken up after 3 weeks.
You have not received the LCR.
Yes, LCR is also not yet still received.
Huh?
LCR is yet to be received and service to respondent number two is
Still
awaited.
awaited.
Yes.
Otherwise, I'm particularly disturbed with it. Take rest it because you have taken stay. Taken stay on this one number 2. When you have taken stay? On number 2 on 29/5.
29
So,
May.
29/5. You have taken stay.
Yes.
Today is 24/7. So service is still awaited. Otherwise, you take rest steps this time. Okay.
Yes.
Card, Mr.
S. Iram.
Huh?
S. Iram.
As Iran, the Lanet Count for the also had Mr. J. Gini, the Lanet for the state respondent number 1. From the office note dated 19/7/2023, it reveals that the LCR as well as the service report for the respondent number 2 is still awaited. Issue reminder, and the petitioner is also directed to take rest steps on respondent number 2 to register AD and SBM process. Let the matter be accordingly listed after 3 weeks. Take rest steps.
May I please, I would mention item number 21 on behalf of Popada, respondent.
He is not present.
He's out of station, ma'am.
It's an appeal.
Letter may be listed.
The appellant is behind the bar, still behind the bar, or he is out of.
Pardon, ma'am.
He is still in the jail, Hajut, or he is on bail. Your appellant? You don't have any idea.
No, no idea.
List after 2 weeks. List after 2 weeks.
Item number 13, there is interim order. That may be.
Where?
Item number 13.
1-3. Interim be continued 3 weeks. Service is already completed.
Completed.
Service is complete. Your for respondent. One. Who is also there or no?
Two is there, insurance company.
Lordship, I am for respondent number 2. Lordship, may allow me to file an IA for striking of my name from the respondent.
Otherwise, you were appearing for respondent number 2, it's a company.
Yes, the company.
Now you want to?
Yes, Your Honor, Lordship, I'd like to file an IA for striking of my name from the respondent.
This is a case basically for.
Your Honor, the insurance policy that was an
was not
action.
valid.
Yes, it was found to be fake and false. So in that case, there is no cause of
So
action.
you are the owner.
I'm the owner, Lordship.
Sorry,
I'm
you are
the
the owner.
Yes, Lordship. I've been directed to pay the compensation amount. So we have preferred an appeal challenging that the tribunal has erroneously granted the compensation upon us, Lordship.
You are for the claimant. But the question is that, okay, you can file an IA. But the challenge is there that the court below had arrived at a.
Lordship, the
finding that-
grounds taken in the appeal, there is no grounds also taken against me, against the insurance policy. So because the insurance policy that was annexed in the claim petition, there has been proved to be fake and false in the review petition. So in that case, there is no cause of action against me. Because the policy has already been,
Okay, oh, you can.
yes.
Heard Mr. G. Talo, the learned-
So in this case, what happens is that whenever this preferred with regard to against the order for the degree of payment of money. So whenever this the case they stay, if there is a stay prayer that they have put before this honorable. So if there is a stay, then a certain amount has to be deposited. So in this case, Your Honor, very unfortunately, I just came to know about the order today that the stay has been allowed. But
You're already allowed.
yes, sir. Yes, Your Honor. The stay was allowed, but without any security deposit. That would be.
Lordship, regarding that, Lordship, the facts of the case, Lordship, are such that if I am directed to pay anything, Lordship, that will be very prejudiced to me, Lordship.
That is the procedure.
That be the procedure, Lordship. Then again, Lordship, this honorable court has, in my understanding, discretion, Lordship, based on the facts of the case, Lordship, whether the case warrants that a security may be, because, Lordship, I am in no manner connected in this case. Actually, I was in the trial court. Then again, the liability came upon me, so I have preferred this appeal on that ground. Aside, leaving aside other grounds, Lordship.
By which order you are saying that the stay was there?
Lordship.
The order was passed on
33, Lordship,
30,
30 March.
30th March.
Yes, there was an IA, Lordship.
that IU was.
Oh, the I was there.
I was there.
What we have received, we had only received the petition. So then IU was disposed even before we appeared before this honorable.
Do one thing. Otherwise, there's an order on stay, and what he has submitted that actually they are not at all liable, whatever, they are sufficient. But from the findings of the court, it is that as the insurance company is not liable or the fake insurance of course was there. So obviously, in that case, the owner has to pay. That is the order, and the order was passed. Now, the question is, stay has already been there, so I cannot pass any order at this stage. However, you have liberty to file in any interlocutory application that may be heard
Then I.
regarding the devolution. You can include your liberty.
Then I-
Otherwise, that will be heard and discussed or disposed of. At the same time, you also are liberty to file an I
Yes.
for striking out. In that case, possibly they have to
We can make an
file the
objection. Lordship.
objection, because otherwise your name cannot be deleted rightly without hearing the other side. So you cannot be but to file the petition, you are not liberty to file the petition. Okay. Mr. G. Talo,
Gita, Lordship.
learned counsel for the appellant, and also heard Atakuna. Learned counsel for the, and your good name is not reflected? Your. I said, so and so. This case is at the stage of admission hearing, but the learned counsel appearing on behalf of the insurance company, Mr. So and so, has submitted that he is going to file an interlocutory application for striking out the name of the insurance company, as he is not at all liable to pay any compensation in this case. Further, the learned counsel appearing for the respond number. You're for respond number 1. Yes. So respond number 1, MS so and so has also submitted that while passing the stay order, there was no order for any payment of any deposition of any money or out of the award before the school, and accordingly, she submitted that she wants to file an interlocutory application for payment of any percentage of the awarded amount before the court. Both the petitioner, respond number 1 and 2 are at liberty to file the interlocutory applications if any. The matter will be heard on the admission hearing on the next day, along with the interlocutory applications. Let the matter be accordingly listed. How many times you want? How many weeks? 3 weeks. Let the matter be listed. Let the matter be listed after 3 weeks.
Much obliged.
My lord, this is a criminal petition, Your Honor. This is a criminal petition under
Yes,
482 of your chair
Ah,
PC,
yes.
Your Honor. For causing of the charge sheet number 8, 2023, 2023, Your Honor.
Is it charge sheeted matter?
Yes, already charge sheeted. And Your Honor, this is filed by the, this is a joint petition filed by the husband and wife, Your Honor. And matter has been already settled between the parties.
It's the case of what section?
Section
498?
498A, Your Honor.
For the informant and the accused, they have jointly filed this petition? They have jointly filed this?
Yes,
petition?
jointly filed by the petition, both the petition. Husband and wife.
Now they are residing together?
Yes, Your Honor. And I have annexed,
Settlement, amicable settlement was there, no?
yes, Your Honor, I have annexed,
76 years old.
no, initially it was registered under 376.
Ah,
During the investigation that IO of the investigation officer has filed the charge sheet under section 498A.
376 was strike off.
Yes,
Subsequently, the case was charged under section 498 only.
498 only.
Compromise, etc. are there here.
Yes,
Will be annexed.
yes, my lord. My lord, annex number 3 is the settlement agreement.
Page number.
Page number 31. That after the intervention of the relative and family members, the party has been settled.
Yes, Mr.
This matter is currently covered by the parameters drawn in Lakshmi Narayan as well as the Kapil Gupta, the joint petition.
Yes,
Will be disposed.
much obliged.
Please, Your Lordship. This is a bail application filed under section 438 CRPC.
Yes.
Here, earlier, Your Lordship, here interim was granted to the petitioner,
Interim was there.
who was granted, and it was directed within 7 days. She
Yes.
was undergoing medical treatment, that this honorable court had directed that within 7 days after her treatment, she should appear before the IO of the case and give her statement. That has been completed, and this
She
is the
already
receipt
appeared.
copy. See, yesterday. She yesterday appeared before the IO and given her whole statement and executed the bail bond before the IO Nalagan PS case number. This is a Nalagan PS case 111 of 2023.
Sections are 409, 420, 423, 465, 467, 460,
Here,
471,
Brief fact
477.
of the case is that, Your Lordship, here there was some misunderstanding. The complainant and the
We have received the
Repeat
CD.
is that.
Yes, ma'am. My lord wishes to peruse the CD. I'll only take my lord to page number 9.
9.
Statement of the complainant, and page number 12 is the statement of the accused. Page number 9
Page number 9.
9
The statement of
of the complainant,
complaint.
if I may read my. On being examined, he stated that above, and I am a public leader staying in so and so as well as so and so. On 12/7/2023, about 8:30 hours, while our family were doing breakfast, then the two-person came to our house in the white Fortuner car, and the duo started asking me about borrowing this 50 lakh loan by a lady, Mrs. Yahum Kapak, who is the alleged accused man, on the basis of the gift deed agreement and money received with me, on which I got surprised as I had never did any gift deed agreement with anybody, and I never met Miss Yahum Kapak in person in my life. Then I incurred the matter from them, on which the duo revealed that in 2022, I made gift deed agreement with Miss So-and-so by selling my plot of land measuring about 12 square meter located at so-and-so Naharlagan, where I'm presently staying by constructing a building of 50 lakhs. By showing me the agreement copies where my signature was forged one. Then the duo started discussing that I took the amount of 50 lakh from the lady at the rate of 5% interest for the 6 months, and in case of failing to return the amount, my said plot of land with building will be taken over as per the agreement. They revealed that amount was taken by Mrs. So-and-so by showing them that agreement. Later, it has been learned that the lady, Mrs. So-and-so, is an employee of DC office, Itanagar under land branch, where she might have used my land allotment records and did such fake agreement and collected the amount of 50 lakh from the duo in lieu of that agreement. The duo also revealed that once they were provided with a check by the lady, but it was bounced. In actual, in 2018, I took loan from then Vijaya Bank, now Baroda Bank, Itanagar, to construct the house by mortgaging my allotment order book, and from then my allotment book is Baroda Bank only. But she made such fake agreement probably by collecting information from land branch of DC office Itanagar, where she was working without my consent or knowledge. Also, the countersign of the executive magistrate was also done in the agreement by ESC so-and-so as per the official record. My lord, the FIR was received to the effect that this, my lord, the alleged accused, this lady, my lord, she has prepared a gift deed showing that the present complainant has gifted his government allotted land to the alleged accused person. And at the same time, she has prepared a money received amounting to worth around 50 lakhs, showing that the complainant has taken a loan from the accused person. By using those two documents, my lord, she used to take loans from other various persons. So that is the only issue in this case, my lord.
The land is shown to be executed in her favor.
Yes, my lord.
And in the same time, it is also shown that he took a loan from.
Loan from the complainant has taken the loan from the accused.
From the accused.
Accused. With these two documents, my lord, she used to show that document as a, by keeping as a mortgage, she used to take loan from the other people. So this is how the complainant came to know. But the government land is basically allotted to the complainant. And the statement of the accused, my lord, is in page number 12.
Page
12, my lord. On being examined, she stated that I am stated above so and so. In the year 2022, Simiti so and so came to my house with a land allotment document with so and requested me to manage loan amount of 50 lakh only, and said to me to approach and borrow the said loan amount from one Sri Biswadar, who is a contractor from Dibrugarh, Assam. But initially I refused, as I had never approached or took loan from Sri Biswadar earlier. But due to her repeated request, I know Simiti Jinta Cherry since last 4 to 5 years, as she was dealing with business of local beads or ornaments. Thus, at last, we both went to Dibrugarh to the residence of Sri Biswadar, whom I know since last 8 years. And during meeting at his residence, Simiti so-and-so asked loan of amount of ₹50 lakhs from Biswadar. Biswadar replied that if I take risks, then he is ready to lend the loan with 5% interest per month. And he advised me to prepare and execute deed of agreement on his behalf. That is, said agreement should be in my name. After meeting Biswadar, Chinta Cherry and I stayed one night at hotel in Dibrugarh, Assam. And on next day, we returned back to Itanagar. After a few days, I prepared money received and one gift deed and forwarded to Biswadar through WhatsApp. And then he transferred the said amount of 50 lakh into my account. The transaction amount could not be finalized later due to Simiti so-and-so suggesting that she and I should divide 25 lakhs each out of total amount of 50 lakh, which I refused, and I immediately informed Sri Biswadar that I am taking the loan transferred by him, and I promised to return him back with 5% interest per month, on which he agreed, and I monthly transferred the interest into his account and also to his wife's bank account. Earlier, he also borrowed a sum of 15 lakhs from me, which I transferred in favor of his firm, BK Construction Itanagar, as we both together participated in tender work and also done supply work under government of AP. On 8/7/2023, I went to Delhi for my medical checkup along with my son, as he also suffers from a stomach ulcer. And on reaching Delhi, I got seriously ill due to food poisoning, and I went for treatment at 3 a.m. on so and so, where I was admitted. In between, I received a call from unknown number who asked me whether I'm Simiti Yagum Kapak, to which I replied yes. Then the person introduced himself as Tana Chika and alleged me that I took loan by forging his signature and placing security of his land allotment documents, which I denied, and informed that I am out of station for medical treatment and requested to wait till my return back to Itanagar and will explain the matter. And then came to know that the FIR has been lodged against me at Nahar NDPS. Basically, my lord, she was working as a UDC in the land department in the office of Deputy Commissioner of Land. So she has randomly taken executed deed of agreement or executed allotted the allotment documents from the land department, and randomly she has picked a land allotment document, and accordingly on the basis of that she prepared a forged agreement stating that the complainant has gifted the land allotment to the accused person, and by showing those documents, my lord, she used to take loans from the other person. That is the only case. If I take my lord to the agreement, my lord, it's in page number 14, and 18 is the money received. However, in this case, my lord, the investigating authority has, though objected, but has not made any whisper about the requirement of custodial interrogation. It's in the status report, is in the first page.
Yeah, Lordship, already the matter has been, there is the settlement going between the complainant and the accused petitioner. That due to this misunderstanding, that neither that land property has been sold or been mortgaged by some other, only due to misunderstanding of fact. Actually, loan was being asked by one lady, Jinta Cheri. Then this petitioner went along with her to Dibrugarh. The petitioner, one contractor, Biswadhar, who was doing some supply contract works in Arunachal Pradesh. So they went, then later that the loan could not be given to that lady. Then the loan was personally taken by the petitioner, and that was informed to the Biswadhar, and she's paying the interest of 5%. Now matter is on the verge of settlement between the complainant and the petitioner. There is nothing, only this is done only due to misunderstanding. That both were not known to each other.
And due to misunderstanding, one can forge the signature also?
No, this signature, petitioner have not executed the signature, Your Lordship.
Who
This agreement was done on the instruction of the Biswadhar, that he is willing to, sorry, Your Lordship, he is willing to give the loan amount, but at the rate of 5% interest. But that could not be executed later on. So, Your Lordship, after hearing that, petitioner is presently also undergoing treatment, but she rushed from Delhi, came here, and after the interim was being granted, she have totally cooperated with the IO of the case. Whatever the statements she was asked, what are the documents she was being asked, she have cooperated. So, Your Lordship, she is a lady and a local person. There is no chance of she's absconding or tampering or hampering with the evidence or connected with the case. So, Your Lordship, I pray that Your Lordship, there is here that FIR also is written. There is no in FIR also, Your Lordship, it is the complainant have also stated that she doesn't know that person. The petitioner also have stated that she doesn't know that person. Some other person bought the agreement before the petitioner, and he went to she went to Dibrugarh, and that Biswadhar, after meeting him, when he agreed, then after his instruction, when my amount was transferred to him, then agreement was made, but it cannot be executed. So here, no any land of complainant has been harmed or complainant land has been sold to some other person. Not only when a complainant suddenly came to know, then he lost this complaint. Now matter there now him and she is fully cooperating, and she'll cooperate further. She'll not hamper, and she is also a government employee, and mother of 4 children. So your lordship, she have no any other cases.
Being a government employee,
She is cooperating. So
If I may,
she have her own permanent resident over here. She is a local over here. So there is no any chance of
she
escape.
a long order, I'm going to pass it.
So I pray your lordship to make this prayer as well. Absolutely, your lordship.
Okay,
Mhm.
right?
Okay.
May I please, Lordship, this is an application under code 39 CRPC. The case is, Lordship, this is, first of all, this is a, X person is a woman, having 16-year-old daughter, and is a widow. And the case began as per this Annexure 1 FIR, page 12. As per the FIR, already search-sheeted matter, Lordship. May I read the contents of FIR? I am to inform you that on 14th November 2022, at around 2300 hours, information received from sources that suspected delivery of drugs is reported to be made at Engineering and Forest Medical Colony area, Longding. Accordingly, a police team comprising of self constable and the Constable Ranjit Sergeant along with the executive magistrate Sri Digara, accompanied by ADC Longding, left for the site area. On arrival at suspected area, trap was laid at the tri-junction area. Later on, after some time, a lady, namely this accused person, Pantam Gangsha, came at the spot, who is reportedly involved in the drug peddling and one of the kingpin in the Longding Township area. And accordingly, based on the input, the house was raided and searched. During the search, 9 soft case packet with blue seal plastic and found from the house weighing about 385 grams approx in the cash amount of 4,44,290 was also found during the raid, which is reportedly the sale for receipt of the narcotic drugs, and accordingly it was seized on the spot in presence of the independent witness and the executive magistrate Longding. But on the spot interrogation, she revealed that she has purchased the drug from unknown person from the Myanmar and also sold some packets within Longding town. However, she did not cooperate with the investigation and even did not reveal the person whom she has sold, in spite of the ADS team continuous engaged in tracing the sold drugs within Longding Township area, but all efforts went in vain. This is the case. And on the spot, it was seizure was done on 14. And as per the annexure 13A,
how many witnesses
this is
are already been
arrested on the next date.
How
on the,
many witnesses are already been examined?
no witness has been examined.
Just it is.
Yeah, this is
Case
the
of
case.
evidence.
And arrested on 15. On the next day, it was seized on the last day. Last day. And on the next day, she was arrested on 15, 14, seized this seizure drugs. And 15, she was arrested. And there are a number of times successive bail application was filed before this concerned trial court. As per the last successive bail application before the trial court, the argument was placed before the concerned court below that the ground of rejection on the earlier bail application was that FSL report is yet to be received, although charge sheet was filed. But on that day, at the date of this argument of the bail application of merit, the learned magistrate has said FSL report has been received, so bail cannot be granted. That was the observation of the court below. The bail has not been heard on merit, whether at this stage, because case is already certified. Neither the court proceed for trial, and nor is grant the bail, whereas the accused person has been inside the jail since from the date of arrest. It is today till today. It is 251 days. Date of arrest is 15 November 2022. Today it is 251 days. As per the law, it is generally 90 days, but NDPS case, on the request of the prayer of the police concerned officer, that can be extended to 180 days. Even thereafter also, if it is not charge sheeted, that can be extended as per this. But when it is charge sheeted, the investigation process ends when the charge sheet is filed before the court below. But when this accused person filed bail application before the concerned court below, but court is not ready to hear the case on merit. Under what circumstances bail cannot be granted? Bail cannot be granted because there is apprehension that the accused person may not cooperate with the investigation agency. That is one of the grounds. And another ground is he may influence the trial process. He may influence the trial process, or mere or any other ground which may be a reasonable cogent reason, a reasonable ground for which bail cannot be granted. But ground for this rejection of the bail is that FSL report has been received because you are involved in the case. Because FSL report is already FSL report has been received, so bail cannot be granted. That cannot be a ground for rejection of bail, because the state has to show that there is a sufficient ground for denial of bail. Why is it? Because on human consideration also, she's a woman and a widow and having a small daughter and a school going daughter. And on that count also, bail was pleaded at this stage, bail may be granted. But in this situation, allegation, whatever it may be, serious it may be, allegation is allegation. I may be allowed to defend the case before the trial court. As and when called for, I am ready to cooperate with this trial process, and I may be allowed to go on bail in this case, because I have lots to do for my family, because there is nobody to look after my child also. There is only lone child, and my husband has already died. This is the case. Only allegation is allegation. At this stage, it is a humble prayer before this honorable court is that at this stage, bail may be granted, and I may be allowed to participate in the trial process.
May it please your lordship. Your lordship, the offense under which the case has been registered is 21C, and 21C speak about commercial quantity. And your lordship, as your lordship is well aware, when commercial quantity comes, section 37 is attracted, your lordship. There is a two grounds which has to be fulfilled by the accused person or the applicant, your lordship. The first is whether the court satisfy the existence of reasonable ground to believe that the accused is not guilty of the offense. And second is, your lordship, while on bail, the accused is not likely to commit any offense. And if either of these two conditions is not fulfilled, your lordship, the bar will operate. He or she will not be entitled for bail. And in addition to that, the other limitation for granting bail under CRPC will also be included with this exception, your lordship. Now, here in this case, your lordship, the quantity is commercial one. And so far as your lordship regarding the FSL is concerned, your lordship, it is now filed. But your lordship is well aware that there are catina of judgment where it says the control over FSL is not upon the investigation authority. investigation authority has to fulfill the criteria which has been given under 173. And even if FSL is not filed along with the other charge documents or the charge sheet which is required for the complete charge sheet, the non-inclusion of FSL will not make the charge sheet incomplete, Your Lordship. So the charge sheet, it is admitted fact that the charge sheet has been filed earlier prior to the filing of the FSL. So for the purpose of default bail, it will not work because FSL is not a condition precedent for filing the charge sheet, Your Lordship. And now, so far as the Your Lordship, the detention is concerned, Your Lordship, these two conditions has to be, they have to come across. If either of these two conditions is not fulfilled, Your Lordship, bar will operate. And Your Lordship may kindly come to the order of the learned court below, the finding, Your Lordship. There are two more cases are pending against the present accused, Your Lordship. The same NDPS case, Your Lordship, meaning thereby she is a habitual offender, Your Lordship. So it's in Your Lordship, page number 18, Your Lordship. In their petition, Your Lordship. Yes, Your Lordship. I will come to her statement also, Your Lordship. Regarding Your Lordship, second satisfaction that while on bail, whether she is likely to commit any offense or not, that will be satisfied, Your Lordship, from this para 18 only, Your Lordship. Page 18. May I read, Your Lordship? Accordingly, a case being Longding PS case number 49/2002, that is the present case, under section 21C Act was registered, and the OCPS himself took up the investigation. He is in the course of investigation, seized the suspected drugs weighing 385 grams, that is commercial quantity, in presence of the magistrate, and also prepared inventory of the same. He also found the accused to be a habitual peddler who has also been arrested in Longding PS case number 37/720 under section 21A NDPS Act, and Longding PS case number 12/2021 under section 21A NDPS, read with section 34A AP Excise Act 1993, Your Lordship. It's on record, Your Lordship. So meaning thereby, Your Lordship, again, if suppose she is released at this stage, again she will involve in this kind of activity. So the second at this stage, the second condition, Your Lordship, that while on bail she is not likely to commit any offense or not. For this record itself, Your Lordship, established that again while on bail she will commit the offense again, Your Lordship. And so far as, Your Lordship, first condition is concerned, whether the court is satisfied that there is a reasonable ground to believe that she is not guilty of the offense, that will, Your Lordship, suffice from her statement itself. That is in Your Lordship, it's 161 statement. It's for the purpose of bail, Your Lordship can consider the 161 statement. That is in, Your Lordship, page number 47, Your Lordship. Pagination 47, Your Lordship. That is not with me, Your Lordship. May kindly perish it, Your Lordship. It's not a part of the record, Your Lordship.
47.
Yes, Your Lordship.
Her name is Srimati.
Pangsa Wangsa.
Huh?
Pangsa Gangsas. Your Lordship, may I, Your Lordship, find out the page number, Your Lordship.
Here is a 47 is there.
Pangsa Namsa, Your Lordship. It's Srimati Pangton Gangsa. Pangton Gangsa, yes. Her statement, Your Lordship. There itself, Your Lordship, she has admitted that she is engaged in peddling, Your Lordship. It's not a case she is the victim in the sense she used to take drugs and all because of some addiction. But here is a case she is involved in peddling, Your Lordship, and it's a menace to the society. And therefore, Your Lordship, when commercial quantity involved, the Supreme Court clearly held that in NDPS case, where this kind of offense, where peddling involved, then in such case, negation of bail is a rule and its granting is an exception, Your Lordship. So, Your Lordship, to substantiate my, Your Lordship, submission, I will rely only one judgment, Your Lordship. And secondly, Your Lordship, on FIR also, I will make submission, Your Lordship, because the material was seized on 14th and she was arrested on 15th. And FIR was registered on 15th itself, Your Lordship. First on, Your Lordship, the section 37, I will rely, Your Lordship. Para, Your Lordship, this is case reported in 2007, volume 7, SCC 798, Your Lordship. Para 5 is the, Your Lordship, is the definition of section 37. And I will read from para 6, Your Lordship. May I read, Your Lordship? As the provision itself provides that no person shall be granted bail unless the two conditions are satisfied. They are the satisfaction of the court that there are reasonable ground for believing that the accused is not guilty and that he is not likely to commit any offense while on bail. Both the conditions has to be satisfied. If either of these two conditions is not satisfied, the bar operates and the accused cannot be released on bail. Now, your lordship may kindly come to para 11. The court, while considering the application for bail with reference to section 37 of the Act, is not called upon to record a finding of not guilty. That is, your lordship, the direction to the learned court while recording the bail. It is for the limited purpose, essentially confined to the question of releasing the accused on bail, that the court is called upon to see if there are reasonable ground for believing that the accused is not guilty and record its satisfaction about the existence of such ground. But the court has not considered the matter as if it is pronouncing a judgment of acquittal and recording a finding or not. That is the court which was recorded. And 12, your lordship. Additionally, the court has to record a finding that while on bail, the accused is not likely to commit any offense. And there should also exist some material to come to such conclusion. Therefore, Mr. Lordship, on cosmetic ground, it shouldn't be recorded. There must be a material that she is not likely to commit any offense, but there is sufficient material against her, Lordship. And so far as your lordship FIR is concerned, regarding the FIR, your lordship, it was registered on 15th, but seizure has been done on your lordship 14th night, your lordship. Its timing is 23 something hours approximately. Here, your lordship, this is the your lordship the 2020 SCC online Karnataka, your lordship, Karnataka High Court 15 page number 1533, your lordship. Just for reference, your lordship. Your lordship, the Lalita Kumari case, what it says, after commission of the cognizable offense, it is duty cast upon the investigation authority to register the case. But there are certain situations where offense has not been committed. So in such case, the duty is cast upon the police, not to record the FIR, only commission of the offense. But if there is a information from the reliable source that offense is likely to commit, then even in such case, investigation authority has a duty to prevent the commission of the offense, and later on they can register the FIR. So, your lordship, it is there in page para 10 and 11, your lordship. May I read your para 10, your lordship? 10. Examine whether the ratio in Lalita Kumari Supra is applicable in a situation where a police officer only receives a credible or secret information about an offense which is about to be committed. I may with great respect observe that the primary duty of the police is to prevent an offense from happening. Immediately after receiving the information, a police officer has to proceed to dispute for averting the crime and taking such other measures as situation demand. In Lalita Kumari Supra, the focus is on the duty of the station officer once he receives information about commission of the offense. That means the information should disclose a crime being already committed. And in such a situation, if the crime is cognizable, the SHO is bound to register FIR without wasting time. But the secret information does not disclose a crime being committed. It only alerts the police about a crime which is about to occur. The police officer who receives such information has to proceed to spot for preventing the crime or to take such other measures that the situation demands. Thereafter, if he prepare a report, it may be treated as FIR for further course of action. Sometimes offense do take place in presence of the police officer. In such situation, his duty is to arrest the accused and collect the evidence and not registration of FIR. In the case on hand, what the police officer received was a report about likelihood of offense under NDPS Act being committed. The informant only suspected possession of contraband substance regarding which no FIR could be registered without ascertaining the truth in the information. The seizure points now disclosed that the petitioner and other accused possess contraband substance for the purpose of selling them. He seized these substances and made a report of the same. No error can be found on it. Here, your lordship. Both the cases clearly cover this case as well. So, your lordship, they has to satisfy this court on two aspects. Even if they come across one of the condition, if not the second one, even in that case, bar will operate.
Lordship, just a few line reply to my brother. Actually, to my understanding, as per the section 37, this operates during the course of investigation. When it is charge-sheeted.
No, I don't think so. I cannot agree with you. This is not within the investigation, but at the after
during the investigation, there is one of the conditions is that PP has to be heard. And another condition is that,
There should be a satisfaction.
another condition is that, without hearing the PP that case cannot be, the accused cannot be released on bail. And another condition is, I have to prove that I am not involved in the case as per the section 37. This is, however,
Perspective, there should be
this is
satisfaction of
this is the
court.
law. So now, what is the situation? When the investigation is already charge sheeted against me, this is the situation. Then what is the duty of the court? Court is to see whether during the course of trial, under section 37D, is there any statutory bar against the court not to grant bail to the accused? This is the situation. But it is not the case. It is the case, the court has the every power to grant bail during the course of this trial, unless some otherwise is proved. This is the one of the case. And number two is cardinal principle of criminal law is that person is to be treated as innocent unless it is proven guilty before the competent court. The allegation of my friend is that there is a similar nature of case, many cases against him. Under that given situation, she cannot be granted bail. But it is against all those cases, I'm ready to face trial. And in this case also, I'm ready to face trial because since case has been already charged. And with regard to this Lalita Kumari case, this is not the preventive detention. I am not under preventive detention. I am under some allegation is there. That is why I have been charged and cases before the trial court. And ground for rejection is that the court has already received the FSL report, so bail cannot be granted. It is not the case that you cannot be granted bail because you may involve similar nature of the case in the future. This is not the ground before the trial court observation. So under the given situation, my prayer is that as earlier is at this stage bail may be granted because I am suffering. I cannot tell to anybody at this stage. So as per the taking into human consideration of the situation, bail may be considered on merit.
Okay, I'll pass the order, but however, your petition will be rejected. Yes.
Deeply obliged.
The last occasion LCR was called for. Yes, Lordship. This is a bail application, Lordship. In connection to,
In this sense, the charge sheeted matter.
yeah, charge sheet, it's already in trial.
Trial.
Yes, Lordship. Lordship, this is in connection to Balimu PS case number 07-2022, registered under section 20B of NDPS Act. 20B is an intermediate quantity, Your Lordship. The section is for intermediate. Your Lordship, may I kindly take you to page number 15, Lordship. It's the FIR, Lordship. Page number 15. Mary. It is to inform you that my sources inform me that some illegal activities is taking place in Boro Plains area in Rauta range. Accordingly, self along with SP West Coming, OC Balimu and team proceeded to said place to conducting long range patrolling. During patrolling, we found 20 to 30 head loaders carrying suspected cannabis. Meanwhile, we apprehended one head loader named Sri so-and-so, age so-and-so, resident of so-and-so, carrying suspected cannabis. During that process, his companions fled away, taking the advantage of dense forest, and they left their belongings, including suspected cannabis in the surrounding area. We searched all the surrounding area and recovered suspected cannabis bags, and accordingly OCPS Balimu seized the suspected cannabis with following due process. After completion of seizing process, we spoke to Magistrate Kalakang for destruction of seized item, and after giving reasonable explanation for not being able to transport seized item to concerned police station, as the number of bags were high, in each bag also weighed heavy and they had to carry it uphill. Magistrate Kalakang has given order to dispose the seized item on the spot in telephonic conversation. Accordingly, after same sample collection, the seized items has been destructed by burning in the site. Your Lordship, FIR was lodged on your Lordship 13/12/2022, and the same day the accused person has been arrested and he has been in custody for almost 8 months. Your Lordship. Now the Lordship, as your Lordship is already aware, Lordship, in NDPS case, the seizing and destruction or disposing of the contraband is to be according to the process of NDPS Act. There is a strict procedure to be followed. Lordship, what happened here is, Lordship, according to them, 33 gunny bags of suspected cannabis were seized. And on the spot itself, with no magistrate, no independent witness, they have disposed of 32 gunny bags. In this, without any independent witness, without any magistrate, just they have said telephonically conversation from the magistrate. That is not how it is supposed to be done, according to section 52A of the NDPS Act. And further, after destruction, most important thing is to weight the items which was seized. Lordship, they have not even weighed the item. Because according to them, they didn't have the scale, so they just wrote 32 kg approx. All the gunny bags. They have destroyed 32 gunny bags, seized 1 gunny bags, and they said approximately. They are not aware whether the rest of the gunny bags are the same weight or not. After they brought the gunny bags to the police station, and now the funny part is, your Lordship, the witnesses, all the witnesses are police officers, the police personnel who were seizing the property. Now their statement before the learned trial court, their statement is, they are not even sure whether that gunny bag belongs to the accused person or the other person. They are not sure which gunny bags is whose gunny bag they have bought. And they are implicating the accused person as the person from whom the gunny bag was seized. They are not sure whether the gunny bag was his or not. That can't be done. And Lordship, the whole process of investigation itself shows foul play. Lordship. They are in the jungle, seized. They have destroyed there only. They are not sure how much was the quantity, and no independent witness. Now they are coming to the police station and saying 32 kg. And the cross-examination says, all the police witnesses says there was 33 gunny bags which was seized, 32 was destroyed. And the leader, the squad leader who was SDPO, who was leading the operation, according to him, 32 bags were seized, 31 was disposed of. There is contradiction in this statement that the cross-examination I have annexed in this application itself also. All the Lordship, if you, Lordship, seizing inventory report, they have to be done in front of the magistrate. And most Lordship, disposal of the contraband, until the magistrate is not present to certify the disposal, it can't be considered valid. And it can't be, and without the certification of the magistrate, seized property inventory report can't be considered as a primary evidence at all. The whole procedure, Lordship, does not.
How many PWs have already been examined till now?
Your Lordship, almost all the witnesses, and all the witnesses are police personnel only. There is no independent witness.
Evidence is almost close by.
All the witnesses are police personnel. All the police person, they have in the cross examiners, they have clearly said that they are not sure whether the gunny bags they have seized and brought to the police station belongs to the accused person or not. And the SDPO, the person who is leading, he himself is not sure how many gunny bags of the contraband was seized and how much was disposed. According to him, he has seized 32 and disposed of 31. According to other witnesses, 33 was seized and 32 was disposed. This itself draws suspicion of foul play from their side. And their conduct does not bring confidence, Lordship. And he has already been in custody for 8 months. And if lordship, if the the accused person is released on bail, there is no chance that he will influence the witnesses. Lordship, all the witnesses are police personnel. There is no chance he will. And as for the tampering of evidence, and evidence has been tampered by the police personnel themselves, Your Lordship. All the procedure is like that. So, Lordship, there is no need to tamper, and there is no chance that he will do so, Your Lordship. It's all the police personnels are police personnels only, no independent witnesses there. Later on, they were called to the police station, and their statement is just that they came to the police station. That won't be suffice to arrest someone for this crime, Your Lordship. And this is intermediate quantity, Your Lordship. The section 37 also doesn't apply here, Lordship, of that. So kindly, Your Lordship, may kindly release the accused person on bail.
My lord, in the present case, alleged accused person was arrested on 13/12/2022. So as of today, my lord, he is under the custody for 7 months, 11 days, my lord. So far, the trial proceeding are concerned, my lord, the evidence are almost closed, my lord. Oh, secondly, my lord, may I take my lord to page number 15 once again, the FIR, my lord.
1-5.
1-5, my lord. Yes, ma'am. It is to inform you that my sources inform me that some illegal activities is taking place in Boro Plain area in Rauta Ranch. Accordingly, self along with SP, West Coming OC Valimo and team proceeded to the said place to conducting long range patrolling. During patrolling, we found 20 to 30 head loader carrying suspected cannabis. Meanwhile, we apprehend one head loader named Sri Sanjit Basumatre, so and so Assam, carrying suspected cannabis. During that process, his companions fled away, taking the advantage of dense forest, and they left their belongings, including suspected cannabis, in the surrounding area. We searched all the surrounding area and recovered suspected cannabis bags, and accordingly, OCPS Malimo seized the suspected cannabis with following due process. After completion of the seizing process, we spoke to Magistrate Kalaktang for destruction of seized item, and after giving reasonable explanation for not being able to transport seized item to concerned police station, as the number of bags was high and each bag was also weight heavy and they had to be carried uphill. Magistrate Kalaktang had given order to dispose the seized item on the spot in telephonic conversation. Accordingly, after sample collection, the seized item has been destructed by burning in situ. Seized item of the Sanjeev Basumatre apprehended person and sample collected is brought to police station for further action. Therefore, I highly request you to kindly so and so. On the, my lord, the perusal, apparently on the perusal of the FIR, my lord, it discloses the fact that there is a clear non-compliance of section 52A, my lord. Since there's no application which has been filed before the magistrate for destruction of the property, and there was no any presence of a magistrate during the collection of a sample. There's a clear violation of 52A. It's an admitted position.
Telephonic conference with the magistrate. How can it suffice this?
Yes, ma'am. And at the same time, my
And,
lord.
if it is too heavy or too weighty, suppose.
Yes, ma'am.
But 1 kg of cannabis weight is not so much. So it can be carried.
Yeah, of course.
Obviously.
There were
So trucks and trucks are already been
carried out.
There are number of.
In addition, my lord, to my understanding, I find there's a non-compliance of section 42 as well, my lord. Since my lord, my sources inform me. So this this has been carried out on the basis of a tip of my lord. There's no writing down of the information, which is a mandatory, my lord, prior to that.
But
So far,
question
my
is that if he accused, he is a permanent resident of his address locality or
No, he is from Assam.
he is from Assam. So that the stays of his case.
He is working there, Your Lordship. He is a daily wage worker in Kalaktang.
Majuli village, my lord.
That he may belong from Assam, but his address is there, permanent address is from Assam.
Permanent address is from Assam.
If he, at this stage, if he absconds,
Yes, ma'am.
then definitely it will hamper the.
If they can provide a local surety, that would
Surety,
be more appropriate.
Pardon, Mr. Eight, you must say eight,
T gaps.
T. Administrative, yes, we learn it also for the petition and also about messages saying we learn it deeply for the state of the Assam respondent. As a scan copy of the answer has already been received. Page receipt, hard receipt. It is submitted by the learning council for the petition. That the accused is in custody since last more than 7 months, and he was arrested on 13/12/2022, and since then he is in custody. Further, it is submitted that from the FI itself, it reveals that there's no compliance of section 52 as well as 42, 52A as well as 42 of the NDPS Act. Further, it is submitted that almost six numbers of witnesses are already been examined where there is sufficient contradiction in the evidence of all the witnesses, whereupon it is very much evident that they have not complied with the provision of they have not observed all the formalities while at the time of seizure, as well as at the time of the disposal of the contraband. But is submitted by the London Council for the petition that that there is no chance of any there is no chance of probability of influencing the witnesses at this stage, as almost all the witnesses are already been examined. More so, most of the witnesses are taking this person. He will appear before the London Special Judge each and every day of his date fixed by the court. If he is granted with allowed to go on bail, and there is no chance of absconding it, as he is a permanent resident of his address community and is ready to produce the proper security. Next point. The learned witnesses is saying has submitted in this regard that the case, almost all the witnesses are already been examined in this case, and he also submitted that from the FIR as well as from the other proceduralists, etc. It reveals that there is a clear violation of section 52 as well as 42 of the NDPS Act. And further, it is submitted that considering his length of detention already undergone, considering the length of detention already undergone by the accused, and also considering the stage of the case, he may be released on bail. After hearing this submission made by the London Council for both sides, and considering all aspects of the case, as well as the length of detention already undergone by the accused, I find it a fit case to allow the accused to go on bail. If you want to raise the security, it will be a local means, will be able to produce the local security, or it will be security from Assam only. At this stage, you cannot say.
Yeah, Lordship, he's our
Because, okay, will be with one security. I don't use the word local, otherwise, but one security. No, like it will be okay with one security, like to the satisfaction of the learned special judge. So, okay, even that.
keep developed.
May it please your lordship.
Still available. We have taken all
For
the,
2 and 3.
yes, we have taken the fresh steps. And in respect to respondent number one,
One is already completed.
already presented.
Already present.
Yes. However, they haven't filed their wakalatnama till then. And
Yeah,
lordship.
they have already completed 2 and 3 is still
Still
available.
available.
So take fresh steps.
Lordship, I may created this respondent number two in respect to service of notice upon respondent number 2 and 3 through substituted manner and publishing newspaper.
Why all other processes are being exhausted?
Your Lordship, because this dusty service is not possible. Because
Why is not possible? That's the services.
Lordship, the
The respondent number 2.
respondent number 2 is the owner. And the respondent number 2 is the driver. Respondent number 3 resides in Sonitpur district, Assam. And the other one is at Bomdila. And the company does not have any operating office there in both the places. So in that case, dusty service it won't be possible. So in that case, through substitute manner, the one of the,
But reports of respondent number 2 are still awaited or return answer?
is still awaited.
Still awaited.
Yes, first one
Yet
has
not
written
returned.
answer, and first one has written answer.
Answer.
Yes,
And then
after that we have taken fresh step. That is still awaited.
you don't have any permanent address of both these days, 2 and 3?
We have
These are the permanent addresses.
yes. The address
Should
that
be
is,
served to registered AD or and all process we have been exhausted.
yes,
We have taken steps.
yes. And lordship, the
Most of the
claimant,
cases, what happens is paper publication can be given, but service to paper publication is seems very rarely it is served actually. Very rare. Because otherwise if you don't have any alternative then definitely. Now, this is cases, file you be only cases for quantum or what?
no lordship, the case was filed under 166.
No, now appeal is for quantum.
No, not for the quantum, for the liabilities.
Liability, then
Yes.
to definitely, I mean.
Yes, they are
owner is-
necessary,
owner
they are
is
necessary.
but
Yes.
then paper publication will do, serve the purpose, I don't think so.
Lordship, in that
Okay,
case,
then,
I
yes.
may allow to get instruction that whether a dusty service could be served to, through dusty
Take
service.
instruction, justice service, if justice service can be there, then I think that there is a possibility of service of notice. Otherwise to paper publication and then to just challenging the liability, so
Yes.
definitely owner will be a necessary party.
Lordship,
Less the party driver, but owner is the necessary party.
lordship,
And owner is the necessary party, owner, the permanent address should be there actually, owner,
No.
because he is the owner.
yes.
So one who is one, by the way,
Is the claimant,
one is the claimant.
Yes.
It is already been served.
yes. Also, one more prayer, here in this case, the claimant has filed an execution petition in the district and session, Bomdila. So the district and session has issued so cause notice on 12/5 of 2023. And however, I have appeared on 6/6 of 2023. So in that case, the district and session has kept the so cause notice for abeyance for a month. The matter is listed on 27 of this month. So if the execution petition or the judgment is not stayed, they may issue a warrant. My humble prayer is as an
Have you
interim measure.
filed any, in that regard, have you filed any stay petition separately in IA or
I have filed a separate
which IA?
IA,
One IA is there, na?
yes.
Two.
What,
IA 252?
252.
There's this 152, 252 IA,
Yes,
no order is passed, you have not taken any steps and condemnation is also still there, I think.
yes.
Condemnation petition disposed of, not
No,
yet.
not yet.
Then what to do?
Lordship,
We cannot
in
jump over
in
the
the,
other,
in the,
otherwise we cannot.
in the
catch.
appeal, as an interim prayer.
Yeah.
I have made an interim prayer till the returnable date, also the,
No, unless and until the delay is condoned, you
Yes.
cannot touch the other file.
Lordship,
That is the issue.
yes.
So you take.
Lordship,
instruction
then
and
an
we
observation, observation.
Make an
made-
observation that you will take instruction regarding the permanent address of so and so. And
Yes.
if dusty mode is possible, then, or otherwise I'll pass an order that you are at liberty to take steps to dusty mode also.
Lordship,
You get the point instruction through dusty mode, it can be served.
yes, Lordship.
But service should be there, that's why.
Lordship.
Otherwise, without disposing the condonation, we cannot jump over the other matters.
Lordship,
So your appeal is not yet admitted or not yet registered, okay? So we'll pass the order, 10, number 10. Administrative tea time,
Lordship,
administrative time, the Learned Council for the appellants as petitioner. The service is already completed on respond number 1, however, no one has represented the respond number 1. Further, it is seen from the office note that the service on respond number 2 and 3 are still awaited. Considering the submission made by the Learned Council for the appellant, the prayer for justice services, the appellant is at liberty to take to issue notice to justice service, dusty mode, and will submit the routed through the registry and will submit the affidavit in the paper. And then the accordingly matter be listed. Your execution is kept till when?
Till 27 this month.
This month.
Yes.
So you make a prayer on 27 so that you can take a stay order or whatever from this court.
That has been already made, exhausted already. Lordship. That prayer has already been exhausted in the district and session Bundila. Because the district and session judge has provided, is granted only 1 month time.
Pray for another 1 month. What can I do? Your petition is
Lost.
still awaiting. No, it's not yours.
Lost.
So if those things, the dusty mode and etc. are allowed, then it will take some time.
Yes.
So can it be listed after 3 weeks?
Lordship.
After 3 weeks, it will be listed.
Lordship.
Try to get it done.
WB.
If an affidavit can be filed, then immediately on that day, we'll pass an order on the stay order.
WB.
Is that question?